Good afternoon, everybody, and thank you for joining us this afternoon. I want to thank our partners in our local chamber, the San Joaquin County Hispanic Chambers of Commerce, as well as our General Counsel, Lisa Blanco Jimenez of Neumiller Beardslee, and of course her firm, Neumiller Beardslee, who's allowing her the time to be able to come online with you all this afternoon. You know, employers will face more compliance challenges in 2021 than ever before. We hope this webinar will provide employers with the resources to bring their workplaces into compliance by 2021 by providing an overview of the new COVID-19 reporting requirements, the new pay data reporting requirements, the new rules on independent contractor classification, the new expansion of the California Family Rights Act, CFRA, and other new laws, as well as a review of best practices for this coming year. Also, as a reminder, we have a Spanish session on Thursday, January 14th, 2021, from 12 p.m. to 1 p.m. as well. CHCC staff will email you registration link to share with your extended networks. Again, thank you for joining us this afternoon. And I would now like to turn it over to Lisa Vela, the CEO of our San Joaquin County Hispanic Chamber. Lisa?
Thank you, Julian, very much. Lisa Blanco Jimenez is a shareholder and principal attorney at Neumiller and Beardslee and the chair of the firm's employment law group. In 2000, Ms. Jimenez graduated from Stanford University with a BA in political science and sociology. In 2004, she received her Juris Doctorate from Stanford Law School. Ms. Jimenez is an AB rated attorney, the highest possible rating for ability and ethics given to attorneys. She was also named a Super Lawyer Rising Star every year from 2013 to 2018, and a Super Lawyer in 2019 and 2020. In 2019, Ms. Jimenez was inducted into the California Hispanic Chamber of Commerce's Hall of Fame for her contributions to the business community. Ms. Jimenez is a member of the San Joaquin County Bar Association, the Hispanic National Bar Association, and La Raza Lawyers of California. Ms. Jimenez sits on the board of directors of the San Joaquin County Hispanic Chamber of Commerce, the board of directors of Visionary Home Builders of California, the Community Council of St. Joseph's Medical Center, and the City of Manteca's Recreation and Parks Commission. Ms. Jimenez was formerly president of the Judge Consuelo M. Callahan American Inn of Court, and formerly a member of the Board of Governors of the San Joaquin County Bar Association, the Board of Directors of United Cerebral Palsy of San Joaquin, Calaveras, and Amador counties, and the Board of Directors of the Library and Literacy Foundation of San Joaquin County. Ms. Jimenez represents individuals and businesses in litigation and pre-litigation disputes and routinely counsels employers in personal matters. Ms. Jimenez lives in Manteca with her husband, Tony, and their 3 boys. Without further ado, I'd like to introduce to everyone Lisa Blanco Jimenez. Thank you, Lisa, for being here today.
Thank you, Lisa. And thank you, Julian, for your opening remarks. All right, without further ado, I want to make sure that we have the time today to review with you the employment law updates for the year 2021. I am available to you after today's presentation, should you wish to consult with me, but please be aware that today's information is for purposes of information only and not to provide legal advice. So our agenda for today, we're going to start with covering the new COVID-19 related laws that went into effect during the last quarter of 2020 and are continuing into the new year. We'll also discuss some changes regarding leaves of absences, some changes regarding the laws concerning discrimination, harassment, and retaliation, an update on worker classification, and some updates on wage and hour laws and best practices for the same. Starting with the COVID-19 related laws. First, there have been changes with regards to workers' compensation reporting and liability. In May of 2020, Governor Newsom signed Executive Order N6220, which provided that all California employees who have worked at the direction of their employer at the employer's worksite, a worksite outside of their home, between March 19th, 2020 and July 5th, 2020, and who tested positive for or were diagnosed with COVID-19 within 14 days of that work, are presumed to have contracted the illness at work for purposes of the workers' compensation benefits eligibility. This is a rebuttable presumption. And then in September of this past year, SB 1159 went into effect, which extended that same rebuttable presumption after July 5th, 2020 through the current date and beyond to two categories of employees. First, the presumption applies to first responders and healthcare workers. And second, the presumption applies to employees who test positive at any other workplace during an outbreak at their specific workplace. For purposes of SB 1159, an outbreak is defined as within 14 days, 4 employees testing positive if the employer has 100 or less employees, 4% of employees who reported to the workplace testing positive if the employer has 100 or more employees, or where the workplace has been ordered closed by a state or local public health department or a school superintendent. So when there is an outbreak under one of these 3 scenarios at any workplace today, the presumption that the COVID diagnosis is work-related applies, and the employee absent rebutting that presumption will be entitled to workers' compensation benefits. SB 1159 also requires employers to notify their workers' compensation carrier if they have any employee with COVID-19, even if they don't think that the illness was contracted at work. So this applies to any employee who tests positive or receives a diagnosis within 14 days of working at the employer's worksite. The law requires employers to report the positive diagnosis to their carriers within 3 days. And employers may be subject to civil penalties of up to $10,000 for intentionally submitting false or misleading information or failing to report this required information to their workers' compensation carrier. Moving on with regards to COVID-19 related laws, you all may require that last year the federal government passed an act referred to as the Families First Coronavirus Response Act, FFCRA. And that act required certain employers, really all employers with 500 or less employees, to provide paid sick leave and expanded FMLA leave for COVID-19 related purposes. And that law expired on December 31st, 2020. So employers are no longer required to provide the leave. However, within the last month, that law has been, although not extended, the employers are given an option to continue to use the advantage of an employer tax credit if the employer chooses to continue to provide FFCRA leave for COVID-19 related purposes. And employers can choose to provide the leave, and if they do, get the tax credits through March 31st, 2021. Information on how to obtain the tax credit is available on the United States Department of Labor's website, as well as the IRS website. We also had some changes with regards to workplace safety laws in light of the COVID pandemic. AB 685 now requires an employer with notice of a potential exposure to COVID-19 in the workplace to do a number of things within 1 business day. The employer must provide written notice of the potential exposure to all other employees who worked at the same worksite as the infected employee during the infectious period. The employer must also provide potentially exposed employees with information regarding COVID-19 related benefits and protections. Finally, employers must provide all employees with a disinfection and safety plan that they plan to implement with regards to the COVID-19 infection in response to it. There are form notices that are available to comply with AB 685. What is considered an infectious period and what is considered a potential exposure are changing almost daily, and the best information you can get about what is considered a potential exposure and what is considered an infectious period is available on the CDC's website. Additionally, AB 685 requires employers to notify public health officials of a COVID-19 outbreak within 48 hours, and this would be your local county public health officer. An outbreak for purposes of this notification requirement is defined as having 3 or more employees diagnosed with COVID-19 within a 2-week period. So this is a different definition of an outbreak than what we are using for the workers' compensation presumption. Most employers are choosing to notify their county health official of every case of COVID-19 in the workplace. But certainly if you've got an outbreak of 3 or more employees in a 2-week period, you're required by law to do so. Our local county office and most county offices in the state of California have a reporting portal online, so you can provide that information electronically. Okay, moving on to leaves of absences under new laws in 2021. And this is probably the most significant change in the law that I can share with you today because it impacts so many employers in the state of California, and it can really change your obligations to provide leave to persons under certain circumstances. So in California, we have a law referred to as the California Family Rights Act, or CFRA, and it is best described as California's equivalent to the federal FMLA law, the Family Medical Leave Act law. And what SB 1383 does is it significantly expands coverage under CFRA. So formally, CFRA only applied to employers that have 50 or more employees, just like the FMLA law. However, effective January 1st of this year, employers with just 5 or more employees are required to provide CFRA leave to eligible employees, which is up to 12 weeks of job protected leave during a 12-month period, and the obligation to maintain employer paid health benefits during the extent of the leave. So again, every employer in the state of California with just 5 or more employees must provide up to 12 weeks of job protected leave to its workforce. Eligible employees can take CFRA leave for one or more of the following reasons: the birth, adoption, or foster care placement of a new child, to care for a family member with a serious health condition, or when the employee is unable to work because of his or her own serious health condition. So these are the same CFRA leave reasons that existed previously and also exist under the federal law. However, it's now applicable to smaller employers. With the expansion of the CFRA law, the New Parent Leave Act, which had gone into effect previously, is basically eliminated in California. So the obligation for employers to provide bonding time or maternity or paternity type leaves has now been rolled into CFRA as one of the reasons for employers to have to provide that leave to their workforce. SB 1383, while expanding coverage of CFRA, also expanded the definition of a family member beyond what had been previously covered under the former version of CFRA, and also beyond what is currently covered under FMLA. So family member, for purposes of taking leave to care for the serious health condition of a family member, now not only includes parent, spouse, or child, but has been expanded to include a grandchild, a grandparent, a sibling, or a parent-in-law, a mother or father-in-law. What this means is that larger employers, those with 50 or more employees who are subject to both CFRA and FMLA, may have to administer those leaves separately, which in some situations could result in an employer having to provide up to 24 weeks of job protected leave to the same employee. To be eligible for CFRA leave, an employee must have worked for the covered employer for at least 12 months and must have worked at least 1,250 hours in the 12 months preceding the start of the leave. So these are the same requirements that existed previously. And of course, CFRA leave is unpaid leave unless the employer requires or the employee elects to use accrued sick vacation or PTO hours. Additionally, an employee may be eligible for paid family leave benefits through the Employment Development Department. So that is a state benefit that could be used to pay an employee a subsidy during the extent of the leave up to 8 weeks. CFRA obligations are very detailed and can sometimes be difficult to navigate. So if you do have an employee that has suffered a serious health condition or has a family member that they're caring for or has a new child, you will definitely want to understand what your obligations are as an employer to provide this job protected leave. Additionally, in 2021, there has been a slight revision to the existing kin care law in California. So the kin care law allows an employee to use up to half of their accrued sick leave to care for a family member. So in the state of California, as you know, employers are obligated to provide sick leave, at least 3 days of sick leave to every employee. And the kin care law simply says that whatever hours you have been given by the employer for sick leave, you can use up to half of those hours to not only care for yourself, but to care for a family member. So when a family member is sick or in need of medical attention. What AB 2017 does in 2021 is revise the law to clarify that the employee has the right to designate the use of their sick leave as kin care leave or not kin care leave in order to avoid an unintentional drawdown of their kin care leave when the sick days they've been using are used for the employee's own illness. So the employee, so as to continue to have kin care sick leave available for their use, can simply designate to the employer that, hey, I'm using this leave for my own sickness, not for a family member, or I'm using it for a family member, so that those leave banks can be appropriately deducted from. Now, an employer does not have to limit the amount of sick leave used for a family member. And if you have a sick leave bank that can be used for the employee's own illness or the illness of a family member without distinction in terms of the number of hours in each bank, then you won't have to worry about making these designations. But if you do have a cap on the use of sick leave for a family member's illness, you'll want to make sure the employee has designated whether the use of sick leave is for their own illness or for that of a family member. Also in 2021, we've seen an expansion of our crime leave obligations. AB 2992 expands existing law, which has already provided protected leave to employees who are victims of domestic violence, sexual assault, or stalking, to also include leave for victims of other crimes or offenses that cause physical injury or that caused mental injury and a threat of physical injury. So employees can now be entitled to protected leave, not just for the limited situations of being victims of domestic violence, sexual assault, or stalking, but any crime or offense where there has been a physical injury to the employee or a mental injury and a threat of physical injury to the employee. In those situations, the employee would be entitled to a protected leave. AB 2992 also provides protected leave for an employee whose immediate family member is deceased as a direct result of a crime. So again, we have an employee who is not him or herself a victim of the crime, but has had a family member who has passed away or been killed as part of a crime. There's also protected leave in that situation. And finally, AB 2992 expands the type of documentation that employee can provide to verify their eligibility for the leave. Again, this is protected leave, not a paid leave, but it is an obligation that employers have to be aware of. Moving on to changes in the law with regards to discrimination, harassment, and retaliation. First, with regards to complaints of retaliation that are brought to the Division of Labor Standards Enforcement. This is a division that is part of the California Department of Industrial Relations. The DLSC is most commonly referred to as the Labor Commissioner's Office. And the Labor Commissioner's Office processes certain kinds of complaints of discrimination. In particular, discrimination alleged on the basis of having filed for unemployment or having exercised a leave of absence with regards to jury duty or with regards to other kinds of protected leaves. The Division of Labor Standard Enforcement of the Labor Commissioner's Office will process those complaints of discrimination. And prior to this year, the employee had only 6 months to bring that kind of retaliation complaint. Beginning this year, the time for bringing that complaint has now been extended to 1 year. So the employee can initiate a complaint. The Division of Labor Standards Enforcement will investigate that complaint if filed within 1 year. There has been no change to the period of time that an employee can bring a civil lawsuit against the employer for discrimination or retaliation, and it's also not required that the employee file a complaint with the Division of Labor Standards Enforcement before going to court. So that those time periods still continue to remain the same. However, if the employee does want to get an investigation done by the Labor Commissioner, they now have up to a year to file that complaint. Also, with regards to complaints filed with the Department of Fair Employment and Housing, which is the state agency that enforces laws under the Fair Employment and Housing Act, so violations of FEHA. Last year, AB 1870 extended the time for filing complaints from 1 year to 3 years. So this is now the second year that this timeline has been in effect, this extended timeline, and we are seeing a trend of an increased number of complaints given the considerable expansion of the time frame for doing so. So these are complaints of sexual harassment, race discrimination, disability discrimination, and complaints of that nature that are now being filed with the Department of Fair Employment and Housing. Now, unlike the Labor Commissioner process, an employee must file with the DFEH before they can go to court and sue the employer. So this is a prerequisite to filing a lawsuit, and given that the time for doing this kind of complaint has been expanded from 1 year to 3 years, we are seeing a considerable influx in the number of cases and the number of charges that employers are having to defend. Sexual harassment prevention training, as you know, the law was recently expanded so that not only supervisors are required to be trained every 2 years, but all employees, if you have at least 5 employees, must be trained on the prevention of sexual harassment, other kinds of harassment and discrimination and retaliation. So last year, the deadline for providing that 1 hour of training to all your non-supervisory workforce was extended from January 1, 2020 to January 1, 2021. So that deadline has now passed. And if you haven't already made sure that your employees have been trained, you'll need to make sure that that happens sooner than later, and then continues to happen every 2 years. In the last 6 months, the DFEH has put out a free online training portal. So this training can be completed free of charge online. The training is available in 6 different languages. And on the screen now is the website where you can access that training portal. Not only is the 1 hour training available online free of charge, but this 2 hour training that's required for supervisors is also available in 6 languages on the same website. So you should be able to easily comply with your sexual harassment prevention training obligations free of charge and remotely. Finally, we have a new pay data reporting law that's in effect for 2021. SB 973 requires private employers with 100 or more employees to submit pay data information, a report to the Department of Fair Employment and Housing that contains information about their employees' race, ethnicity, and gender in various job categories. And this information must be submitted to DFEH by no later than March 31st, 2021. And the information must be submitted in a format that is searchable and sortable. More information about the new pay data report requirement is available on the DFEH's website at the link on the bottom of the slide. I also have an update on workers' classification. So you may recall in 2019, we had the AB 5 legislation, which expanded or codified a new definition of what is an independent contractor or not. And effective September 4th of last year, AB 2257 introduced a number of amendments to AB 5, and it newly exempted certain categories of creative workers, including writers, photographers, videographers, photo editors, and illustrators. So as of today, we now have 109 categories of workers that are exempted from AB 5's ABC test. Additionally, AB 2257 redefined exemptions for business-to-business relationships, referral agencies, and professional services, among others, to greater expand who may be treated appropriately and legally as an independent contractor. So if you have not gone through the analysis of your independent contractor workforce in the last 6 months, now would be a good time to do that, to see if you can continue to properly classify your employees, certain workers, as independent contractors, or reclassify them as employees if the law does not allow for an exemption. Finally, with regards to wage and hour updates, you will recall with regards to the minimum wage in 2016, SB 3 was enacted, which provides for increases to California's minimum wage every year for 6 years beginning in 2017. This is now our 5th increase. So as of 2021, employers with 25 or less employees must pay a minimum wage of $13 per hour. And employers with 26 or more employees must pay a minimum wage of $14 per hour. It is important to note that the increase in the hourly minimum wage also translates to a concurrent increase in the minimum salary for exempt employees. Under California law, in order to qualify for an exemption under the wage and hour laws, exemption from overtime, rest breaks, meal periods, etc., you must pay your exempt employee a minimum salary of 2 times minimum wage for full-time employment. So it's a simple mathematical calculation. You take the minimum wage, you multiply it by 2, and then you multiply it by 2,080, which is full-time employment at 40 hours a week for 52 weeks in a year. So under that calculation, if you have 26 or more employees and your minimum wage is then $14 an hour, every one of your exempt employees must make at least $58,240 a year in order to meet the exemption. So that's the minimum salary you have to pay your exempt workforce. And there is no proration of that. So regardless of whether the exempt employee works 40 hours or 25 hours or 60 hours, that is the minimum salary that you must pay them per year. And it must be a true salary. So they get a fixed amount monthly or biweekly, whatever your payroll cycle is, regardless of the number of hours worked. And that will continue to be a number that increases year after year as the minimum wage continues to increase. Also, with regards to exempt employees, now that we're in this pandemic situation, there have been a lot of changes in the workplace to workforce. We have employees that are covering other people's positions. We have employees that are working reduced schedules or being furloughed. And it's very important to note that for your exempt workforce, if you're going to continue to pay them on an exempt basis and not hourly, you need to maintain that minimum salary regardless of the change of their hours. Additionally, if their duties have changed as a result of the pandemic, you may be in a situation where the employee no longer qualifies for the exemption because they're no longer performing what the law considers to be exempt duties. So if you've had significant changes with regards to your exempt workforce, you may want to conduct a further analysis to make sure that they still qualify for the exemption. There have also been a couple of changes to the rest break laws that are particular to very specific industries. As a reminder, in California, employers in most industries must provide their employees with a 10-minute rest break for every 4 hours worked or major fraction thereof. So for a typical 8-hour day, the employee would be entitled to 2 10-minute rest breaks, 1 in the morning or before lunch, and 1 in the second part of the day or after lunch. And the break must be provided in the middle of the work period to the extent practicable. So typically that means an employee will work for 2 hours, take a 10-minute break, work for 2 more hours, take a lunch, and then do the same thing in the afternoon. Employers are prohibited from discouraging the taking of an uninterrupted off-duty rest break. So although these rest breaks are paid, the employee is entitled to an uninterrupted off-duty relief from their work. So you can keep them in the workplace, you can require them to stay on site, but you can't be giving them work or requiring them to answer phones or answer questions during their rest breaks. If you do require them to work through rest break, or if a rest break isn't provided because the work does not allow them to take it, there is a premium to which the employee is entitled for not having been able to take the break. And that is 1 hour of pay for every day that the employee is not able to take the break or is discouraged from taking that break. And these premium payments can really add up, and continues to be in 2021 one of the areas that we will see a great deal of litigation being brought against employers. There were a couple of exceptions in 2021 to the rest break law. AB 1512 provides now an exception for security guards, and they are, during their rest breaks, can be required to stay on the premise and remain on call, ready to work. And if their work interrupts their rest break, then the security guard must be able to restart the break as soon as possible. And so long as they're able to do that, even if it's later in the day, the premium that would otherwise be paid to the security guard for a violation will not be required. And then also AB 2479 provides a limited on-call rest break exception for safety sensitive positions at petroleum facilities through 2026. So we have a couple of exceptions here in 2 particular industries, but beyond that, the law continues to remain that employees have to be given these rest breaks. And again, this is in addition to the unpaid meal period of 30 minutes or more that are also required under the wage orders. In 2021, we've had some changes to enforcement of wage and hour laws, in particular AB 3075, which specifically makes a successor employer liable for its predecessor's unpaid wage judgment. So if there's been a change in ownership in the employer, or a company that is merged with another or acquired by another, that liability for a judgment for unpaid wages will continue to the successor employer. And successorship is defined by the statute and pretty broadly defined. So a successorship includes where the business that is the successor employer uses substantially the same facilities or substantially the same workforce to offer substantially the same services as the prior employer judgment debtor, or has substantially the same owners or managers that control labor relations as the prior judgment debtor, or employs as a managing agent or any person who directly controls the wages, hours, or working conditions of the workforce as the judgment debtor, or operates a business in the same industry as the prior entity and has an owner, officer, or director who's an immediate family member of any owner, officer, or director of the prior entity that was the judgment debtor. So this is a law that is meant to prevent people from escaping judgments for unpaid wages by changing their name or selling their business off to a family member, or making some kind of other changes to their structure. And this allows that judgment to continue to be enforced as against the new or successor employer. And there are also in AB 3075, some additional requirements about reporting to the Secretary of State that you have an unpaid wage judgment. So at the time that a corporation, for example, must file their statement of information with the Secretary of State, they'll also have to designate if they have an unpaid wage judgment out there. That concludes the material I'm presenting today. So I will now go to your questions and see if I can answer some of them for you. Okay, so one of the questions I've been asked is whether you will receive a copy of the presentation. So you can email me at the address on the screen, and I will be able to send you a PDF of the slideshow. Additionally, the California Hispanic Chambers of Commerce has recorded this presentation today, and I do believe it will be presented, available online. So if someone from CHCC wants to provide more details on that.
Hi, Lisa, this is Alex. Sorry. Sorry. Yes, we will be pushing it out on our YouTube channel.
Okay, great. So CHCC will have the presentation available on the YouTube channel as well. We also have a question about whether you have to report to CAOSHA within 3 days, and presumably that has to do with a COVID diagnosis. So the CAOSHA reporting requirements are the same that they've always been. So for example, under CAOSHA, if you have certain kinds of injuries or illnesses in the workplace that have caused a loss of days, you're required to report that information within 24 hours. So that hasn't changed. What's the only thing that's impacted by the COVID pandemic is that employers are concerned about whether they have to report a COVID diagnosis to CAOSHA, and you only have to do that if it's a work-related illness. So if you have reason to believe that the employee contracted COVID in the workplace, then you will also have CAOSHA reporting requirements in addition to the workers' comp carrier reporting requirement. Okay, so if the workers' comp reporting requirement, you have to do that even if you don't think it's work-related. But for CAOSHA, your reporting obligation is only triggered if you have reason to believe it's work-related. And very often that has something to do with having a known exposure in the workplace or one of these outbreak situations. There will be some thought or presumption or belief that it's work-related. And so then you would be obligated to report to CAOSHA. Okay, so there was a question about how worksite is defined, particularly with regards to larger companies that may have multiple buildings in the same geographic location. So worksite, you can define it in terms of a building or a work floor area. So for example, if you have employees that in a particular department and that department only works on the 3rd floor of your building, then you can limit the definition of worksite to just that 3rd floor location. However, if you occupy 2 floors of a building and employees are working not in one floor but are moving between floors, then you may have to expand your definition of worksite to the 2-floor area of the building. But unless you have employees that are moving from location to location on a regular day in their during their workday, then you don't have to use multiple locations as one work site. You can treat those as separate work sites. Okay, so it's a little bit dependent on how much travel is happening between workplaces, but if you have sort of a defined work area or work site for an employee, then you would treat that as the work site. If you have just one office, it's the one office. If you have 1 floor of a building, it's the 1 floor of the building. There's also a question about the CFRA expansion and the protections that it provides. So the employer, the question is, does the employer have to provide paid leave or simply leave without pay? And how about the costs or benefits or medical plans during the absence? Does the employer have to bear that cost too? Okay, so CFRA is a job protected leave, not a paid leave. So the obligation is that you provide the time off and that you restore the employee to their same or similar position at the conclusion of the leave. So they got to have their job back. You've got to keep their job open. That's the obligation. You don't have to pay them during the leave. If they do have accrued sick time, you can require that they use it, or the employee can request that they use it. If you have a vacation or PTO bank, you can require that the employee use it, or the employee can request that they use it, but otherwise it's not a paid leave, not a leave paid by the employer. There are benefits available to an employee to be paid by the government during a CFRA leave. So the employee, if they have their own illness, they can apply for SDI through EDD. If they're taking care of a family member or they are bonding with a new child, they can apply for paid family leave, which is another kind of SDI program through EDD. But again, that's not you paying. That would be a program that they would be able to apply to EDD for. The second part of the question had to do with benefits. So yes, you have to maintain the benefits to the same extent you did previously and the same extent you would if they were still working every day. So if you pay 50% of the premiums, then you'll continue to pay 50% of the premiums throughout the leave. All right, so that is a cost obligation to the employer that you're having to maintain your share of these premiums during the leave. Now, the employee is going to have to maintain his or her own share of the premium as well. So typically what happens if you're paying the employee, for example, sick time or PTO time, what you would do is you would deduct from those paychecks the employee's portion of their benefits. So you would continue to make that payroll deduction for premiums. If the employee is not getting paid anything because they don't have any sick time or vacation time on the books and it's just the unpaid leave they're taking, then what you would do is you'd have to make arrangements for the employee to pay their share on a monthly or biweekly basis, however it is that you require it. And so long as they're paying their share, you pay your share and the benefits would be maintained. There are also rules about recovering the cost of healthcare benefits in the event the employee decides they never want to come back from their leave. And if that happens, you do have some rights under FMLA and CFRA to recover what you had to pay to maintain their benefits since they never even came back. So there's lots of details and nuances on these laws, but that's a good question and hopefully that addresses it. There was a question about whether CFRA runs concurrently with PDL. So that hasn't changed and the answer is yes. So there is a pregnancy, the answer is it hasn't changed. So there is a pregnancy disability leave that you may be aware of, and that's where an employee who is disabled, so actually disabled, this is not a baby bonding situation, but an employee who is actually disabled as a result of pregnancy or childcare can get up to 4 months of job protected leave and continuation of benefits in order to address that disability. So all those rules are the same. The expansion of CFRA hasn't changed those rules at all. There was a question about where you can find more information on kin care. And the best place for you to find that information is through the Labor Commissioner's website, or the DLSE is what it's called, the Division of Labor Standards Enforcement, which is the California state agency that enforces our wage and hour laws. And if you can just look up on the DLSE website kin care, and it's usually a discussion in connection with the sick leave law. So the paid sick leave law and the kin care law kind of work together. All right. There was a question about the time period for filing complaints of harassment or retaliation. So, and the comment was that it seems like it's a really short amount of time. And I think that has to do with the 6-month period for the DLSE complaint that was extended to 1 year. Now, again, you don't, for the DLSE retaliation complaint, the employee does not have to file a complaint with the labor commissioner within that 1 year time frame in order to bring a lawsuit. So if the 1 year time frame has run and that's expired, the employee can forego filing with the Department of Labor Standard Enforcement and go straight to filing a lawsuit. And that time period is up to 3 years under the laws governing wrongful termination. So that's still a pretty expansive statute of limitations. And then with regards to the Department of Fair Employment and Housing process for discrimination, which is a different set of laws, that time period has been expanded to 3 years. So 3 years is generally the time frame that an employee has to take action, which is considered a pretty expansive time frame under California law. There was also a question about how many employees do you need to have, what is the minimum number of employees you need to have to do the sexual harassment prevention class? That's 5 or more employees. So if you have 5 or more employees, you need to have them train, all your employees train on sexual harassment. Your general workforce every 1 hour every 2 years, and all your supervisors and managers 2 hours every 2 years. All right. Now, the sexual harassment laws themselves apply even if you have only 1 employee. So you cannot engage in sexual harassment with even 1 employee. That employee can sue you for sexual harassment, but the training obligation applies if you have 5 or more. All right. So somebody asked, if you have an exempt workforce, what is the minimum salary if you have under 26 employees? So this is the situation where you've got the lower minimum wage. So what we do, I can do the math really easily, is you take the $13 an hour, you multiply it by 2, and then you multiply it by 2,080, and the minimum salary is $54,080. Okay. There was also a question about timekeeping for the paid rest breaks. And the question is, do the breaks have to be recorded on the employee's time card? So the answer is no. You do not need to record the rest break on the employee's time card. Conversely, the meal period, the lunch break, must be recorded on the time card. So time cards under California law for your non-exempt hourly employees must show the time they started their work period, when they clocked out for lunch, when they clocked back in for lunch, and then when they clocked out for the day. Okay, but rest breaks, the paid rest breaks, do not need to be recorded in any way. Having said that, best practice is to record them in some way to acknowledge that the employee has taken their rest break. And a lot of times, some people have a rest break schedule so they can coordinate the taking of rest breaks among their various employees so they don't, overlap too much and whatnot. And people will kind of initial that they've taken their rest break for the day. Most employers don't do that, and I won't fault you if you don't, but that's one way of doing it. The best way probably though is to, as part of your time card or your timesheet that your employee fills out every week or 2 weeks, is have a statement at the bottom of the time card that says, by my signature, I certify that I have worked all the hours reported on my timesheet and that I have not worked any hours not reported on my timesheet, and that I have taken my rest breaks and my lunch breaks. I mean, some kind of a statement like that the employee signs. Is it going to be absolute evidence in every case? Is it going to allow you to win any lawsuit that gets filed against you? No, there'll still be a factual dispute about whether the employee really did take their rest breaks. But at least it gives you some additional assurances that you can say, hey, I didn't know the employee wasn't taking their rest breaks because they signed this document every week or every 2 weeks saying that they had. And some employers will even have an extra column on their timesheet where the employee can initial that they took the rest break for the day. And if they didn't, make a note of it, because then your payroll people can pay them the hour for the day. Because if you pay the hour for them missing their break or their lunch, then you're good. They're not, you've done your duty. That's the penalty or the premium for missing the lunch or the break. So if there's a way that the employee can note that they had to work through a break because things were really busy or a customer came in or they got a call or whatever the case may be, and they note that and you pay the hour premium, then you're good. It's been documented, it's been paid, and you're not going to face some of these, class action type lawsuits that we see that result from these kinds of violations. We had a question about whether employees are required to provide evidence of testing positive for COVID-19. So that had to do with that Family First Coronavirus Response Act. Remember, that's the law that I said expired on December 31st. So if you're not going to be providing COVID leave going forward, then all these rules about, when the person's eligible and their documentation are kind of out the window. But if you are going to continue to provide it, and so that you can get the tax credits and give people time off to recover, then you can continue to do that through March 31st and get those tax credits. Documentation, the rules say that if you're going to get the tax credit, you need the documentation. At the same time, the rules say, even if you don't get the documentation, you still need to provide the leave. So employers are kind of in a catch-22 of how much they chase after evidence of the diagnosis. So what I've been telling people is you should ask your employee, you should tell them, hey, we require this. You should, follow up with them on it, but, you probably shouldn't say you don't get the leave. But at this point, we're sort of beyond the leave requirements. Anyway, but if your question has to do with whether or not you need proof of it in order to report it to workers' comp, no, you don't need the documentation in order to report it to workers' comp, or if you've got an outbreak situation, you need to report it to public health. You don't need that documentation in order to make that report, and not having the documentation is not going to relieve you of the obligation to report. So you're going to want to go ahead and make those reports as soon as you're aware of it or told that that's the case. Having said that, if the employee is really going to pursue a workers' comp claim, then ultimately they're going to have to see a workers' comp doctor. They're going to have to go through the whole process and provide proof of the diagnosis. But it's not something that you'll need to require before making your report. All right, so we had a question about whether the minimum wage of $14 per hour needed to be prorated as of 1/1/2021. I'm not quite sure what that means in terms of a proration. I mean, it's $14 per hour as of, midnight on 1/1/2021. So if once the employee has started to work into the new year, those hours going forward are at $14 an hour. If sometimes pay periods will cross into years. So if you got a pay period that has the last week of December and the first week of January, your minimum wage workforce may have, you know, half the paycheck at $13 an hour and half the paycheck at $14 an hour. That's fine, but you're not going to actually prorate an hour. All right. All right, so there was a question about giving breaks and a workforce where the employees are driving from place to place to perform services. So this is a cleaning service, and so they're presumably going from a different building to a building or from a house to a house in order to provide services. And the question is, can they get their 10-minute break while in the car? So while the owner or a driver is driving the employee, can they take their break basically sitting as a passenger? And that's a really interesting question. I mean, certainly if they're the ones driving, the answer would be clearly no, because they're sort of on the clock during the time that they're engaged in work for you, and that work, that effort is the driving from place to place. If they're merely a passenger, I guess that would be the same as requiring them to stay at their desk during the breaks, but telling them not to work while they're on their break. So telling them to stay in the car while they're on their break while you drive and telling them not to work would appear to be compliant with the law. Having said that, you want to be really careful not to turn that break time into an off-duty situation. Are they able to eat during that break? Are they able to take a personal phone call? Are you going to be talking to them about work stuff? How much are they free to do their own thing if you're sitting right there next to them? I mean, they can't really call their doctor and check their, you know, their medical information when you're sitting right there. It doesn't really give them a lot of freedom to engage in personal rest activities during that break. So that's a kind of a really dicey situation. And the more constraints on their freedom that you give them that you impose during that break time, the less likely it'll feel like a legally compliant break. So be really careful about situations like that. All right, so there was a question about the time period for paying wages. And the question is, if a payday was on a Friday and some employees were not paid, what are the requirements by law for an employee to pay an employee on time? Okay, so the general rule is that if you work between the 1st of the month and the 15th of the month, you have to be paid by the 21st of the month. So work days between the 1st and the 15th must be paid by the 21st. Work between the 16th of the month and the last day of the month must be paid by the 10th day of the next month. So for example, whatever your employees work between December 16th and December 31st must be paid by January 10th. And so most people have established pay days, either on a weekly or bi-weekly or bi-monthly basis, that meet those minimum requirements. You can pay earlier, but you can't pay later than those timeframes. And the law does require you to have established pay days, have regular pay days every other Friday, every 15th and 31st, etc. But if you're meeting the minimum deadlines that I just described for you for the payday, there really isn't going to be a penalty if a payday is late in one situation. So if you're supposed to pay on Friday and you can't get the checks out till Monday, that's not going to create an issue unless that Monday deadline is beyond the deadlines I just described for you earlier in terms of when the work was performed. Okay. The question is, how long does an employee have CFRA protection? So it's up to 12 weeks of protected leave, and they get up to 12 weeks of leave for every 12-month period. So if they've taken 12 weeks in a 12-month period, then they wouldn't be able to take another 12 weeks until the next 12-month period. Okay, so we are coming up on the hour mark. So I will turn it over to our host to close out the event. If you have any other questions that I couldn't get to, there were a number of questions here that I wasn't able to answer, feel free to email me, or you can also reach out to the San Joaquin County Hispanic Chamber of Commerce staff or the California Hispanic Chambers of Commerce staff in order to get a hold of me. And thank you for your time today.
Thank you, Lisa, and thank you everybody on today. Like Lisa said, her email's up on the screen right now, so we'll leave it up for the next few seconds here. Everybody can make sure you write it down. CHEC will be posting this on YouTube. It should probably usually up by the next morning, so you should see it. If not this afternoon, maybe even quicker. So thank you all again for joining us. And just a reminder, we will be doing a Spanish version of this webinar on Thursday, same time, 12 p.m. Be on the lookout for that as well. We'll be sending a reminder email to you folks too as well, saying, hey, if you know anybody or if you yourself would like to hear this again in Spanish, please join us again on Thursday. With that, thank you, Lisa. Thank you, San Joaquin Hispanic Chamber of Commerce, and thank you all of you, and have a great rest of your day. Bye-bye.